For Creamer Media's Polity Mtabi Madiba, Namibian Supreme Court Justice and author David Smuts joins me to discuss his book titled Death, Detention and Disappearance. Can you tell us a bit about your life as a young schoolboy living in Pretoria and when your interest in politics began?
Yeah, I spent my high school, most of my high school years in Pretoria, and yeah, I was very interested in politics even at high school, and I was very keen to get involved in doing law and to do work which would be fighting the injustices of the apartheid system in place then. And it was towards the end of my high school that my father was transferred in his work to Windhoek, Namibia, then called Southwest Africa, and my family moved there.
And your book covers a traumatic period in Namibia's history and chronicles a dark decade of human rights abuses by South African security forces. Briefly explain to us what prompted you to write this book.
When I finished studying and I started working in Windhoek, where my family was living, I became very involved in human rights work. And that was the reason why I wanted to study law in the first place. And the work just became so all-consuming as the military occupation by South Africa of Namibia intensified, and the militarization of the South African state's approach to Namibia also intensified. So you had martial law in more than half of the country, the northern part of the country, and where there were no lawyers working, and there was an occupying army and massive human rights abuses. And that's when I really started out my practice, and it was dealing with and confronting those kind of abuses and trying to address them in court and assist my clients in fighting those injustices that were in place then. It was quite different to doing that kind of work in South Africa in a way, because although you had detention without trial and you had some of the other you had racial discrimination, detention without trial, and a lot of the really awful aspects of apartheid which applied in Namibia, it was a little bit, it was considerably different really, especially in the northern part of Namibia, because you had martial law. You didn't really have law properly enforced, and you had an occupying military force dealing with a low-level war of insurgency in the country. That obviously led to wide-scale human rights abuses, and was challenging those abuses that was the primary focus of my practice from 1980 to the independence of Namibia in 1990.
Mm-hmm. And can you briefly tell us about your days in the 1980s as a defense lawyer in Namibia, and why did you feel compelled to take on the apartheid system?
Yeah, the system was really just like in South Africa. It was all pervasive. It was a really unjust system, and even from my school days in Pretoria, I knew that I wanted to take on that system in court, and that it was very important to do that kind of work. And so that's what I set out to do. It's just that we'd moved to Namibia, and I'd made Namibia my home, and I got involved in the Namibian issues and on behalf of my clients there. And I think that it was my sense of justice and repugnance at the injustice which made me get very involved in that kind of work. And once I became involved, it really snowballed. The work became extremely intense, and more work came my way, because so many of the abuses weren't really highlighted until we started digging and delving and tackling those abuses. So the work really snowballed in terms of its volume. And I eventually left private practice to set up a public interest law firm in Namibia, which was closely modelled on the Legal Resources Centre of South Africa. That was in the later 80s when I started that, simply because the volume of work that I was trying to deal with was way too much to cope with and manage from a private law practice.
And talk to us about your relationship with your lifelong friend and colleague, Deputy Judge President Hosea Angula, as young lawyers in Windhoek.
Yeah, Hosea Angula and myself worked extremely closely in challenging these abuses. And he was the first Oshiwamo-speaking person in the country's history to be admitted as a lawyer. He'd come from the northern part, and from his very first day in articles, in fact from his first year as a university student in what was then called the University of the North in South Africa, that's where he studied, he worked vacations in my office, and then after he qualified we worked extremely closely together to tackle these abuses. And it was a great partnership that we had in dealing with these cases, and it's a friendship and partnership which has endured until today. Still, we are very close friends, and on the judiciary now we work closely together. But especially in those years, we formed a very close bond, and we were able to tackle an enormous amount of cases. And Hosea taught me so much about. Well, of course, I learnt Oshikwanyama, one of the main languages in the northern part, and Hosea taught me a great deal about living and in the north and in interacting with the people there. So we complemented each other well in the way in which we combated injustice in those years. So it's a very enduring partnership and relationship which, as I say, still continues to this day.
Briefly talk to us about the procedures you had to undergo in order to get affidavits for witness detainees and other practical difficulties which stood in your way.
Now that was very difficult. Those years were extremely difficult because in the northern part of the country there were no lawyers in full-time practice, and it made life so tough as a young lawyer to get affidavits commissioned. And because the commissioners were bank managers, there were 2 banks in Oshikati at that time, and police officers, and we couldn't go to the police officers because the police were closely involved with the human rights abuses, either themselves or some police units like Kufut, which was formerly a police unit. So we couldn't go there, and our clients would be horrified to have to post an affidavit there. And we couldn't go to the army because army officers were also commissioners of oaths because they wouldn't assist. So it was really a nightmare. If the banks closed early in those days, and it was really tough. And on the one occasion I went to a postmaster, and as is set out in the book, it was quite an awful experience because he was extremely antagonistic to the case. When he read the affidavits, he didn't want to post them. It's only when I won't say I threatened him, but I insisted that he did that, and that it could be a violation of the law if he didn't do it. But it was very, very unpleasant, and he didn't trust our interpreters, he didn't trust me, and it was really difficult those are just some of those are minor difficulties that we faced as lawyers when we were trying to bring cases when getting affidavits commissioned. There are other more fundamental difficulties that were faced, like witnesses disappearing, witnesses getting detained, and those were really far more, made cases often much more difficult. And people, the police and the security police and the military sometimes even interfering in your case. But those made things difficulties, and trying to get people to spy on you.
You mentioned that you knew that senior counsel Arthur Cheskelson must have had many setbacks over the years, but he continued and learned from them in becoming the bastion of principle and excellence. Can you briefly tell us how you felt when you first learned that you lost the case against the apartheid military regarding detainees before appealing it?
Yeah, that was a devastating loss in court, because the people were held in secret for 6 years without trial, and it was a gross injustice. And we had the best legal team that one could think of, because it was led by Sidney Kentridge, and Arthur Chaskelson. And it was such a huge privilege as a young person to work with such legal luminaries. And it was the beginning also, fortunately, of an important relationship that I developed with especially Arthur Chaskelson, who assisted us enormously in Namibia, setting up our public interest law firm, but later he was also involved in Namibia in he was the primary writer of our Namibian constitution. So that was tremendous, but it was a devastating loss when that was lost, because we were in the right and it was argued so extremely well, and yet we lost it. We did appeal it and we won part of that on appeal. But those were some of the difficult times. Sometimes the bench wasn't ready yet to find in our favour. The bench did change a bit in the 80s as more people from the Windhoek legal profession were appointed, and not always outsiders from South Africa. But it was devastating when you lose cases. I lost many of the cases in the first years. The court was simply not ready for those kind of cases. But later on, we did win some cases, and that was important. But even though we lost that case, there was so much pressure internationally on the South African state that they released all those detainees. Just before we went to court, half of them were released, and within another 6 months, the other half were released. So we lost in court, but the case was a success.
You also tackle themes such as death and disappearance. Briefly talk to us more about Johannes Kakuva, whose detention was denied and who later disappeared.
Yeah, in his case, I refer to him briefly in the book. That was in about 1980, or 81, he was detained by the security police, and he was never heard of again, and they denied that they ever detained him. So what then happened was, myself and my colleague Hartmut Ruppel got witnesses together, and it was primarily Hartmut later took that to court, was to demonstrate that he had in fact succumbed. He must have died in detention, and we were successful in obtaining a presumption of death on behalf of his family, to say that presuming his death, because he never emerged from that again, and there were horrible signs of screaming and on his part during the detention, so he died there. But the terrible thing is that no one was ever prosecuted or held to account for that.
Briefly explain to us how struggle activist and a fellow lawyer friend, Anton Lobovsky, was gunned down with a hail of bullets outside his home. Yeah,
that was a terrible case. In 1989, during the time when the independence plan was being implemented jointly by the United Nations and the South African administration there at the time, and it was under UN supervision. And Anton was gunned down, assassinated with the use of semi-automatic rifles outside his house as he was coming home. And there was a coincidence that the lights were turned off at that time, the municipal lights. But later on, when this was pointed out, they were turned on again. There were a lot of coincidences, and there was eventually an inquest held into his death, in which I was part of the legal team. And we believe it was conclusively established that his assassination was by a covert military group unit called the CCB, which fell under the South African Defence Force, that was responsible for his death. All the evidence indicated in that direction. So some of these things which look like weird coincidences were probably carefully coordinated in this calculated killing of Anton. So yes, that was a devastating blow for many of us who knew him, and of course for our process at the time, that somebody involved in politics was being gunned down outside his house. And it would appear that the same group of people, the same covert unit, was also responsible for the death of David Webster. He died in very similar circumstances in South Africa just a few months before. There was a trial, there was an inquest and a trial involved in that, In our case, Anton's killers have never been brought to book. There's never been any accountability. We did have that inquest, and the inquest finding was that those members of the CCB were responsible for his death.
And lastly, what are you hoping people will take away from reading this book?
Well, I think this book is important for Namibians, for us to know about our history and what happened in the country during those years. But it's also important for South Africans to know about the South African participation and history, where South Africa administered Namibia until Namibia obtained its independence in 1990. Under international law, it was regarded to have been an illegal occupation, but it was South Africa's responsibility at the time. And many South Africans were involved, and I think many South Africans need to know what the role of the country was during those times. And unfortunately, it's not a very happy and rather shameful aspect of South Africa's past, which I think people must come to terms with in understanding what had happened in Namibia. And a lot of people were quite involved. Some of them were involved in the military. Some of them were temporarily living there. Some had relatives there. But it is important for the truth to be told about what had happened during those years, or for them to be discussed in this way. And hopefully, both us in Namibia and in South Africa, that we will learn from these human rights violations, and we learn about the abuse of power and lack of accountability. We learn the dangers of that and can draw from those lessons in our current situations in our countries.
Thank you. That was David Smuts speaking to Creamer Media's Polity about his book titled Death, Detention and Disappearance.